Flynn got the new lawyers and they filed new motions. They wanted what's called a writ of mandamus, and let's pull this up. I want to run you through what this order looks like. So a writ of mandamus it's a legal proceeding where it's a legal request where basically they're asking an appeals court to order the lower court to do something. So in this case, in Michael Flynn's case, the lower court judge decided he was not going to dismiss the case. So I'm not going to dismiss it. We're going to hold hearings. We're going to do a bunch of stuff about it. And Michael Flynn's attorney said, okay, that's fine. You're the district court. We're going to go up above you to the appeals court, which is the DC Circuit Court, which is the federal appeals court for the DC Circuit Court of Appeals. And we're going to ask them to order you to dismiss it. And so what happened? Well, we got the order today. The Court of Appeals actually listened to all the arguments. They put together a 38-page opinion and order, which I read almost all of it today. I didn't touch the dissent, which is the disagreement part. So when you get an opinion and an order from a court, you have the majority opinion, which is going to be the rule, and it's going to be the law, and it's going to be the precedent. And then you have the dissent, which is the judges who disagree. So let's go through the order. It just came out literally today on June 24th, 2020. And here's what it looks like. The United States Court of Appeals for the U.S. District Court Circuit, Columbia Circuit. And when you start going through this order, you're going to see kind of a lot of really fluffy, a lot of language. A lot of this is legal stuff, right? So they're saying that Team Flynn. So these are, I was kind of dissecting the parties. We were talking about, who is on whose side. And so we've got petitioners, we've got all these different attorney generals for the state of Alaska, Arkansas, Florida, Georgia, Louisiana, blah, blah, blah. They're all supporting Michael Flynn and so on and so forth. So we just keep going. Everybody's in support of this until we finally get to the opinion, which was filed by Circuit Judge Rao. All right. So here we go. So this is sort of the timeline of how all this happened. So quick recall, what the court will do is they're going to go through what's called the procedural posture. Basically, they're going to say all of this stuff happened. He pled guilty. He withdrew from the plea. The government filed a motion to dismiss. The judge does not grant the motion to dismiss. They appointed what's called an amicus. Okay, so an amicus is a Latin word. It basically means friend, or in legal parlance, it's called friend of the court. And what this judge did, Judge Sullivan, is he said that, no, we're not going to dismiss the charges. What I'm actually going to do is appoint somebody else. An amicus, it's a friend of the court. It's somebody with expertise or wisdom, or the court wants opinions from somebody from the outside of the case, because they're not involved in the case. So it's like, okay, we're all too muddled in this. Our heads are in the weeds. We need somebody from the outside to come in and tell us how we should handle this case. And so they brought this gentleman in. We're going to talk about who he is, to argue against or to basically act as a third party. He ends up arguing against terminating the prosecution against Michael Flynn. So then when the judge did this, so Judge Sullivan says, not going to dismiss the charges. I'm going to bring in and appoint this third party person to come in and give us his opinion. And we're also going to set a hearing so we can discuss these things. The government wants the case dismissed. Michael Flynn wants the case dismissed, but I don't really want to do anything about that. So I'm going to bring in this third party person, and we're all going to talk about it, and we're going to do it in July. So then Flynn's attorney comes back and says, no, we're not. That's not going to happen. We're going to file for this writ of mandamus, which you can see here under the 28 USC 1651, and they're going to ask for these three things. One, an order directing the court to dismiss the case. Number two, they want to vacate the hearing about that, and then they want to get a new judge. So those are the three things that they want. And they get the big one, but we'll save that until we get there. So they go through, and the opinion talks a lot about whether or not they should be granting what's called a writ of mandamus. And so the mandamus process it's a lot, right? It's a superior court talking to an inferior court and ordering them to do something, which is a big deal, right? You don't want that to happen. You want due process in normal courts. You want the courts to resolve things on their own. You don't want, basically you don't want the superior court or the appeals court or the Supreme Court acting almost as like filling in for those lower level courts, sort of supplanting them in a certain way. You don't want that to happen. So you want to let them go through their own process, go through due process, and come to their own conclusions. But when they can't do that, then a writ of mandamus becomes appropriate. And so that's what they're asking for here. They're saying, we want you to order them to do something. And so the majority opinion comes through and they say that we understand that the right to relief must be clear and indisputable. There must be no other adequate means to attain relief. So they're saying the mandamus has to be the last resort. Like we are only going to do this if there's no other ways for us to solve this issue. They go forward and they're really talking about this guy here. So this is Judge Emmett Sullivan. And he talks about the basis for what he's calling leave of the court. So now he's going to sink his teeth into an argument. He's going to say, the reason I did this is because according to Rule 48, I can take leave of court, and I can go make a determination on my own. I can say whether or not I want to grant this motion to dismiss, whether I can or not. And so he's saying, I have full authority under this rule, and he goes through it. And he talks about some of this case law and how it all works. But the court comes back and they say, when the government moves to the principal object of the leave of the court requirement is to protect the defendant against prosecutorial harassment when the government moves to dismiss an indictment over the defendant's objection. That's a fancy way of saying, I didn't show you the screen there. This is a fancy way of saying that if, let's say, for example, that Michael Flynn wanted to dismiss his case or I'm sorry, let's reverse that. Let's say the government wanted to dismiss the case and Michael Flynn objected to the dismissal. There are reasons for that. Then this is the appropriate time for the government to step back in. But because in this case, the government and Michael Flynn are in agreement, this is not appropriate. The leave of absence is not appropriate. They go through, they talk about that there was, Flynn agrees with the government motion to dismiss. There was newly discovered evidence. The Department of Justice, and specifically the government, points to evidence from the FBI, which, where the false statements were allegedly made. They say that the interview was untethered to and unjustified by the FBI's counterintelligence investigation into Michael Flynn. The government says it cannot prove the relevant false statements or their materiality beyond a reasonable doubt. Insufficient evidence is a quintessential justification for dismissing charges. And that's 100% right. So if the government comes back and says, well, we don't have enough evidence, we looked into this thing further and we think that this whole underlying prosecution was corrupt and illegitimate from the beginning, we're not going to continue to prosecute the case. We're not going to do that. We want that to happen. We want prosecutors to have the authority and the discretion to stop prosecuting bad cases. If they see that the evidence doesn't fit, they want to, we want to give them the authority and the wherewithal to terminate that. We don't want people to continue to prosecute cases that shouldn't be prosecuted. So the counter argument to that, right, the response back is, yeah, but this is political though. General Flynn, his case is only getting dismissed now because there's been a changing of the guard. Comey's no longer at the FBI. All of the Obama era appointees are all gone. They've all been replaced. We've had a number of different attorney generals since then. The Department of Justice has had some maneuvers and stuff. And so the critics are saying, wait a minute, now this dismissal cannot be allowed because it's political. The political system has changed, and therefore this thing is it's corrupt. They shouldn't be dismissing this case. It's only being dismissed because Trump put his people in. But Obama had his people in, right? So this all started under Obama's people, and it's ending under Trump's people. So the criticism cuts both ways. If you're going to say it's political, then if you're going to say that the dismissal from the Department of Justice is political, then you also have to acknowledge that maybe the prosecution of General Flynn at the beginning was also political. You can't have it both ways. So it's either political or it wasn't. Well, the court recognizes this. The court knows that that's true, and that is a justifiable criticism. So how does it deal with that? Well, it talks about what they call the presumption of regularity, right? So as opposed to political, the government's representations about the insufficiency of the evidence are entitled to a presumption of regularity. So what this is saying is that if the government comes back and says, we don't have the evidence to move forward on this thing, the court is going to just presume that that is the truth. They're going to presume that that is the regular function of the government, that That's the basis. That's the starting point. We're going to say that we're going to believe them. The presumption starts, we're going to believe the government. The court goes on to say, this carries on, presumption of regularity in the absence of clear evidence to the contrary. So they are saying that if we see some evidence of irregularity, if we see some political bias, if we see some of that stuff, then yeah, they don't get the presumption anymore. But it goes on to say, we don't see any of that here. So here's what we've got. There is no clear evidence in this case on the record before the district court. There is no clear evidence, contrary to the government's representations, that they were operating with regularity. There's no evidence on the record. The justifications that the district court offers in support of further inquiry, for instance, that only the U.S. attorney signed the motion without any line prosecutors, that the motion is longer than most Rule 48 motions, they are all insufficient to rebut the presumption of regularity to which the government is entitled. So the judge in the district court did say, he had some basis for it. He said, well, the motion was a little longer than some of the other motions, or it was long, or maybe it broke the rules, it was too long, or maybe it was, the signature was only from the U.S. attorney, but it didn't have any other prosecutors on there, so maybe this wasn't an office decision. Maybe this was a single prosecutor's decision, which means that maybe that's a little bit irregular. But by and large, those are small potatoes, right? Those are just kind of minor procedural things that are happening. One's a motion's too long, and one didn't have, everybody's signature on it. Is that a basis to presume that the government was operating out of normalcy? They were operating with irregularity, that this whole thing was political and unjustified? No, the court goes on and says, we don't have any evidence about that. We don't have any evidence that any of that stuff exists. And they actually go through and they are discussing Judge Sullivan's rationale for needing the leave. So remember, Judge Sullivan was the one who said, we need more time. We need to investigate this. We need to appoint the amicus, that third-party provider person, and we also need to have a hearing, and we're going to call all these people into court, and we're going to get to the bottom of this thing. And so in his response, so when Flynn's attorneys filed the writ of mandamus, Sullivan gets the opportunity to respond. The judge gets to respond and say, no, this is why I did it. And he did, and he said, here was why he wanted to have this hearing. He wanted to question the bona fides of the government's motion. He wanted to inquire about the government's motions and their representations. He wanted to illuminate the full circumstances surrounding the proposed dismissal. And he wanted to probe whether the presumption of regularity for prosecutorial decisions is overcome in the unusual facts of this case. So he's really wanting to dive in. He wants to open up the government's files and look through them and look through the notes. And he wants to, ask everybody, well, what about this and what about that? And basically, he wants to sort of act as a prosecutor in the case. He wants to vet what the prosecutor's decisions are. But that's not his job. He's the judge. He is not the prosecutor. The prosecutor is the one who gets to make that decision. And they did. And there's no evidence on the record that they didn't do a good job of that. There's nothing that we have seen on the record that shows that this was political or that there was no basis for it. In fact, the opposite is actually true. We're getting more documents on a daily basis showing that they were fibbing this thing all over the place. And the judge doesn't want to accept that. Instead, he wants to call everybody back into his courtroom, and he wants to sort of take control of the prosecution. And the court says, you can't do that, man. That's not your job. You're not allowed to do that. He says under a hearing may be appropriate in some situations, but a hearing cannot be used as an occasion to superintend the prosecution's charging decision, because authority over criminal charging decisions resides fundamentally with the executive, without the involvement of and without the oversight of power in the judiciary, which is exactly right. This is a balance of power thing that I was talking about. This is the separation that we need in order for all this stuff to function. If you have the judge who is acting as a prosecutor, then what do you need the prosecutor for? And if they're commingled to a certain extent, the defense is now outnumbered. The government itself is saying, we don't want to prosecute this guy, but now he's got to go back and he's got to fight the judge and the prosecutor and other people who were involved in the case, like the amicus. So it's not good. It's not a good way to practice law. And the opinion, I think, gets it exactly right. It says the proposed hearing constitutes clear legal error And it just continues to move on. Now, a big part of this opinion is actually justifying the use of the mandamus. The mandamus is, again, it's the superior court coming back and telling the lower court you have to do something a certain way. And the court spends time on clearing this stuff out. They go through it, see all of this here. It's all case law. It's all, precedent from different jurisdictions, from the Supreme Court, from the DC Circuit, and so on, 1998, 2003. So it's all just case law, sort of fleshing out the rules on when a mandamus is appropriate and when it's not appropriate. And so they go on, they reiterate a few things, that the government cannot pry into the government's decision-making power by, if Judge Sullivan got his way, in other words, and everybody was in the government's files and asking the government about everything that they decided to do, it would reveal the internal deliberative process. And it's basically done with the intent to scrutinize the reasoning and the motives of the Department of Justice. And by getting in there and by meddling in that process, you're causing irreparable harm that cannot be remedied. And that's what this opinion says right here. Irreparable harm that cannot be remedied on appeal. And they must step in to prevent the judicial usurpation of executive power. Right? They need to get in, they need to get involved so that this doesn't continue to go on. Because if Judge Sullivan got his way and General Flynn had to go and appear in front of this amicus and all of this stuff, now he's contending against the prosecutor's office and the judge, and he's outnumbered. There's a commingling, there's an improper balance of power in that effect. So that was, I think, a great point. Exactly on point. This was sort of my initial thought when this judge refused to dismiss the case. When the prosecutors in the Department of Justice said that they were going to dismiss the case, I thought that was the end of this for sure. And I was a little surprised that it kept going on and on and on. The court goes on. It talks about this amicus, John Gleason. So that's this guy right here. This was the guy that Judge Sullivan brought in to argue as the amicus. This is the friend of the court type of individual. And the court goes on to point out that the government, if they bring this guy in, it was done so that he could present arguments in opposition to the government's motion. So basically what they're saying is that they brought this guy in to act as a prosecutor. If the Department of Justice is not going to prosecute Flynn, Judge Sullivan comes back out and says, that's fine. I'm going to appoint my own guy, John Gleason, who's going to be the actual prosecutor of the case. He's going to come in and he's going to argue that the government should not have moved to dismiss the case. They should continue to prosecute him. Well, the court says that all of this stuff doesn't matter what happens under Rule 48 and the leave of absence and all that stuff. The rule does not include designating an advocate to defend Flynn's continued prosecution. The district court's order put two co-equal branches of government on a collision course, and that's exactly right. That's exactly what he did. The judge was asking somebody else to come in and tell the prosecutor's office why they needed to continue to prosecute. That's not the judge's job. It's not at all their job. They should be making sure that things are operating, appropriately. But when two sides are in alignment, for the court to go ahead and just dismiss that doesn't make any sense at all to me. Let's keep going through the opinion. So this is the Gleason brief. So Gleason files his own brief. He files the amicus brief. And he says that the government, they used a lot of stuff as a pretext to dismiss the case. Basically, he's making the argument that it's prosecutorial abuse and that it is essentially political in a lot of ways. He relied on news stories, tweets, and facts outside the record to contrast the government's grounds for dismissal, which is funny because when I saw his brief come through, I did see some other defense attorneys who were like, yeah, what a great brief. And I was thinking, what? None of this stuff is part of the record, but even defense attorneys can get political. They can see this stuff. I get political too, believe it or not. But okay, so let's go back to the opinion. It says that the court should be neutral, and it necessarily doesn't get to weigh the merits of the case. So Gleason encouraged the district court to scrutinize the government's view of the strength of its case. So Gleason is telling the Department of Justice, you don't think your case is strong, but we want the judge to go in and verify that your case is strong. And you just can't do that. Again, it's a co-equal branches of government. It's not the judge's job to go in and tell the prosecutor how to do their job. It would be as absurd as a prosecutor going to the judge and telling the judge to do what the prosecutor thinks that they should do, or the defense telling the prosecutor what they should do, or the judge. It's asinine behavior, but this is what came out of this particular case. Now, the Department of Justice is also saying, they quote here, the court quotes here from their manual, as a matter of fundamental fairness and in the interest of efficient administration of justice, no prosecution should be initiated against any person unless the attorney for the government believes the admissible evidence is sufficient to obtain and sustain a guilty verdict by an unbiased trier of fact. And that's their manual. That's something that we want prosecutors to do. We want them to dump bad cases. We wish they did more of that, but unfortunately they do not. Again, they hide behind their policies. The opinion goes on. We'll get through it here pretty quickly. Mandamus justification. So again, the mandamus remedy allows the Court of Appeals to prevent encroachment on a co-equal department, and they're going to do it here. So boom, granted. In part, what they're saying is we're going to grant the mandamus and in part, and we're gonna deny it in part. So if you remember when I talked about this, the Flynn writ for mandamus wanted three things. It wanted the appeals court, to order the lower court to dismiss the case. So it's not, the appeals court is not dismissing it. It's passing it back down to the district court, and it's saying the district court has to dismiss the case. It's ordering them to do something, but it's not the appeals court dismissing itself. That was number one. Number two is to get rid of the hearing for the amicus hearing. So it's saying, that John Gleason guy and that hearing that Judge Sullivan set, we don't want that happening anymore either. And then the third part that Flynn's attorney asked for was for a change of judge. Basically, they said Judge Sullivan is too biased, too political, doesn't know what he's doing, and we want a different judge. So those are the three things that they asked for. And the appeals court didn't give them all of them. It split them. So on the first one, here's what they did. They said, we grant the petition for mandamus in part and order the district court to grant the government's Rule 48 motion to dismiss the charges against Flynn. So that's the first one. Granted, boom, that's the big one. The appeals court is going to be ordering the district court to take the case and dismiss it. Now, when the case gets dismissed, what does that mean? Means that we don't have an amicus anymore. We don't have an amicus hearing. We don't have John Gleason coming in. We don't have any of that stuff happening anymore. So that point is going to be moot. So as to point number two, that's going to be moot. But point number three, we want a different judge. Well, the court says no. The court says no. They say we deny Flynn's petition to the extent that he seeks reassignment of the district judge. No new judge is coming for you. But they are telling Judge Sullivan, the guy who kind of started all this, Judge Sullivan, you are now ordered to dismiss the case. So kind of like a little bit of a backhand, right? You started this whole thing. We're not going to kick you off the case. We're going to send the case right back to your court, and you're going to be the one who has to dismiss all of the charges against General Flynn. So that stings a little bit, right? It's his court. It's his, everybody is wanting to see. He's basically turned this entire case into a circus, and now he has to resolve it on his own. So that was the opinion. Let me show you just the rest of it. Now, I did not read a lot of the rest of it. So this is where the opinion basically ends. They say here that they're going to respond to the dissent. So you can see, if you look at my cursor, this is we're on page 12 here. This is the majority opinion. We decline to reassign a new judge, and we grant the government's Rule 48 motion to dismiss. So they're going to dismiss the case. Then they spend a lot of time talking about the dissent. So all of this here is the dissent, a response to the dissent. So this is the final order. And then this is where the dissent starts. So this is where Wilkins, who is another circuit judge, actually dissents. And the crux of his argument is really that mandamus is not appropriate. He doesn't think it's appropriate at this time. He doesn't get into any of the facts. It's not really a political opinion, really, in either way. But Judge Wilkins is saying that there really is no basis for a mandamus at this time. He says that he reads the Rule 48 requirement for a leave of absence to consider a motion to dismiss is much broader. And he's saying that really, Judge Sullivan and the district court should have had a little bit more leeway. They should have had these hearings, and they should have had an opportunity to review the record before this would become ripe. So in other words, this is not appropriate for the Court of Appeals to be hearing right now, because there's still work to be done back down on the district court. Now, I think the majority opinion addresses that pretty clearly. They say that there would be sort of irreparable damage that would happen if they didn't act right now. Like if this clown show continued to go on, General Flynn, there's going to be a lot more irreparable harm to everybody involved: the government, Michael Flynn, and the integrity of the court. All of these different things. It's not justified under the case law. So it is something that has been going on for a long time. This opinion just came out today. I really don't even know what this judge is going to do. He may go ahead and grant it and grant the motion to dismiss, and then ride out the rest of his time on the bench. But to me, it kind of feels like he was interested in something else. Like he wanted to make this a little bit of a spectacle. Maybe he rides off into the sunset, writes a book about it, and it becomes a best-selling tell-all before the election, of course, because that's what happens now in our political world.